Thank you, everyone. Please be seated. Thank you. If everyone could find their seats, we'll be starting the live stream shortly. Thank you. Silence. All stand and remain standing. The Federal Circuit and Family Court of Australia Division 2 is now in session. Please be seated.
Mr. Associate, please open the court.
On the occasion of the ceremonial sitting to commemorate the 25th anniversary of the Federal Circuit and Family Court of Australia Division 2.
Mr. Smith.
Mandangul, thank you, Your Honour. I acknowledge the Gadigal people of the Eora Nation upon whose land we gather today. I acknowledge their elders, past and present. I extend that acknowledgement to all Aboriginal and Torres Strait Islander peoples of this island continent and their elders, past and present. I acknowledge my First Nations brothers and sisters who are present in this court today, including my youngest son, Albert, as well as those who are viewing this ceremonial sitting online. Sovereignty was never ceded, always was, always will be Aboriginal land. I acknowledge the judges of this honourable court and the plethora of distinguished guests who are present today, whether in person or virtually. In particular, it is my privilege and honour to acknowledge my Indigenous brother, Judge Matthew Myers AM, who was appointed to this honourable court on the 8th of December 2011. Judge Myers was the first Indigenous person to be appointed to a Commonwealth judicial office. I understand that His Honour is not physically present with us today as he is currently on leave, but I am confident that he is with us in spirit, if not virtually. I also take this opportunity to extend my gratitude to His Honour, the Chief Justice, for the personal invitation he extended to me to deliver this acknowledgement of country. That invitation is an example of this court engaging in reframing the view from a window that has arguably been carefully placed to exclude a whole quadrant of the country's historical landscape, and aids the ongoing task of piercing what W.E.H. Stanner described in 1968 as the Great Australian Silence. Today the court is celebrating its 25th anniversary. Before I yield, I take this opportunity to make a few brief observations. The jurisdiction of Division 2 of this court includes administrative law, bankruptcy, employment law, family law, human rights, intellectual property and migration. However, it is my understanding that the substantial majority of filings in Division 2 are in respect of family law. The focus of my observations centre around family, the court's engagement with First Nations people and resilience. At the heart of those observations is a geographic anchor in Wiradjuri country, my people's country, and specifically Dubbo and its surrounds, the land from which my ancestors descend and to which they are forever inextricably linked. Located outside the township of Wellington, New South Wales, not far from Dubbo, is the site of what was once the first rural mission established for First Nations people in New South Wales, namely Manuganai. That mission was established in 1832 by the Anglican Church Mission Society, consistent with the wider royal instructions issued by the Anglican Archdeacon of Sydney in July 1825 to take measures for the civilisation of the black natives of this colony and their conversion to Christianity. The missionaries who resided and oversaw that mission hoped to, in their words, convert the uncorrupted Wiradjuri to Christianity. Reverend William Watson was one of the 3 missionaries who resided at that mission. In pursuit of his aforementioned objective, Reverend Watson began removing Wiradjuri children from their parents under the pretence of protecting and educating the children. The Wiradjuri nicknamed Reverend William Watson Eaglehawk, which is the equivalence of, or meaning of, what is now known as the wedge-tail eagle. His fellow missionary, James Gunther, opposed the practice of removing Wiradjuri children from their parents. It is no secret which point of view ultimately prevailed. The implications, impacts and consequences of those policies and practices were and continue to reverberate from generation to generation of First Nations people. Whilst the official policies of removal of First Nations children from their parents has ceased, it remains the case that First Nations children remain disproportionately represented in out-of-home care. In New South Wales, that number is approximately 40%. On any view, the separation of children from their parents, temporarily or permanently, carries with it substantial risk of harm to all involved. That risk of harm is amplified in a culture which, distinguishable from Western philosophy, that is undergirded by the Voltairean principle of the primacy of the individual, is one centred around the primacy of community, and in particular, family. In First Nations culture, one's identity is as much bound up in connection to country and kin as it is in the sense of self. No doubt, jurists of Division 2 of this court are daily confronted with determining custody and access to children, including access by First Nations people to inter alia their children, nieces, nephews and grandchildren. For such interactions to result in dignity for all involved requires thoughtfulness, extending to an understanding and a regard for First Nations people and their culture. Which brings me to the connection of Division 2 to Wiradjuri country. In 2011, the then Chief Judge Pascoe AO, CVO, met with Aboriginal elders in Dubbo, during which meeting his honour discussed with those elders the lack of access to justice of many First Nations people. That meeting was the genesis for the Federal Circuit Court, as it then was, to embark upon and on 4 April 2014 enter into a reconciliation action plan. The Federal Circuit Court was the first Australian court to enter into a reconciliation action plan. In conjunction with the entry into a reconciliation action plan, on 4 April 2014, in its Sydney registry, the court commenced a specialist Indigenous list for family law matters. Since that time, the court has expanded the operations of its special Indigenous list to other registries of this court, including on and from 2023, Lismore and Coffs Harbour. In addition, the court has introduced Indigenous family liaison officers, whose roles include providing support to Aboriginal and Torres Strait Islander families accessing the courts in family law matters and engaging with the local Aboriginal and Torres Strait Islander communities and support agencies to raise awareness of the role of the courts in family law matters. The number of IFLOs has increased from 1 prior to 2021 to 17 nationally. 12 days ago, the court launched its most recent innovative reconciliation action plan. It seems poetically apt that a court of objective, comparable youth ought to be at the forefront of the vanguard of reconciliation with First Nations people. That the court has played such a critical role and plays such a critical role in the sphere of family law adumbrates the importance of that leadership. Equally, it gives reasons for confidence in those First Nations and First Nations people that come to this court that they'll obtain a fair hearing and hope of just outcomes. In its objectively short temporal existence, Division 2 has been through a number of changes, ranging from name changes to its amalgamation with the Family Court of Australia. The size of the court and its locations for regular sittings have also grown. In going through those changes, it has demonstrated capacity for innovation, agility, and evolution. Speaking from the perspective of the oldest living culture in the world, those are some of the attributes that play a critical role in manifesting the type of resilience required for longevity. As Division 2 embarks upon the next 25 years of its journey, I sincerely hope that it continues its role of leadership in reconciliation with First Nations peoples, that more judicial officers of Division 2 are First Nations peoples, and it retains the attributes of youthful vigour which have to date served it well. On that note, I shall end as I began. Mandangua.
Thank you very much, Mr. Smith. This ceremony has begun with acknowledgement of country from proud Wurundjeri man and member of the New South Wales Bar, Mr. Andrew Smith. I thank him deeply for accepting my invitation to deliver the acknowledgement of country at this ceremony. The Gadigal people of the Eora Nation have been the custodians of these lands and waters for thousands of years. On behalf of the court, I acknowledge them as the traditional owners of this land and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. Ours is a court that sits across all parts of this great country. We acknowledge and thank the traditional owners of all those nations. We acknowledge their unique and ongoing spiritual and cultural relationship to their country. We express our gratitude for the sharing of that country. We also express our sorrow for the cost of that sharing. We walk with the greatest respect on their sacred lands. Well, good afternoon, and thank you all very much for coming today to celebrate the 25-year anniversary of the Federal Circuit and Family Court of Australia Division 2. I acknowledge the distinguished presence of so many guests, including, of course, the Honourable Michelle Rowland, MP, the Attorney-General for the Commonwealth of Australia. We are so very grateful for your attendance today. The Court looks forward to working with you over the coming years and once again, congratulations on your appointment as the nation's first law officer. The Honourable Chief Justice Stephen Gagler AC and the Honourable Justice Robert Beach-Jones of the High Court of Australia. Chief Justice Andrew Bell, Justice Julie Ward, President of the Court of Appeal, the Chief Judge in charge of Equity, Justice David Hammerschlag, and other judges of the Supreme Court of New South Wales, judges of the District Court and Local Court of New South Wales, including the Deputy Chief Magistrate, the many judges and former judges of the Federal Court of Australia in attendance, judges of the Federal Circuit and Family Court of Australia Division 1, including many members who are actually former judges of this court. Former Chief Justice of the Family Court, the first Chief Justice, the Honourable Elizabeth Evatt AC, is here today and we're delighted to see you. I note that your successor, the Honourable Alistair Nicholson, has sent his apologies and congratulations to the court. Former Chief Justices of the Family Court of Australia and also former heads of this jurisdiction, the Honourable Diana Bryant, AOKC, and the Honourable John Pascoe, ACCVO, are both with us here today. They both led this court with distinction and should be very proud of what they've achieved. Former judges of this court and other courts, Ms Roisin Annesley, KC, President of the Australian Bar Association, Ms Vanessa Whittaker, SC, Junior Vice President of the New South Wales Bar Association, Ms Julianne Warner, President of the Law Council of Australia, Ms Jennifer Ball, President of the Law Society of New South Wales, and many members of the profession and distinguished guests. On behalf of the court, can I especially thank Chief Justice Mortimer and the judges of the Federal Court for extending us the privilege of sitting in this magnificent courtroom. It is not the first time it has been made available for our court's most significant occasions. Between each visit, our court has grown, and we are now well and truly testing the limits of both the judicial bench and what is usually the associate table. I now invite the Attorney-General for the Commonwealth of Australia to address the court, the Honourable Michelle Rowland, MP.
May it please the Court. I too begin by acknowledging the traditional custodians of the land we are meeting on, and I recognise and pay my respects to Aboriginal and Torres Strait Islander people here today. It is a great privilege to celebrate the 25th anniversary of the Federal Circuit and Family Court of Australia, Division 2. I very much appreciate Chief Justice Alsterdgren's invitation to speak today. I acknowledge the many eminent current and former members of the judiciary and the legal profession who are also present. I'm honoured to be here as Australia's 40th Attorney General on what happens to be my 41st day in the job. I approach the role of Attorney General with great humility and a deep sense of responsibility, and a commitment to upholding the rule of law while promoting public trust in Australia's legal system. That includes the vital court system, of which the Federal Circuit and Family Court of Australia is a valued component. The FCFCOA Division 2 began its life as the Federal Magistrates Court under the newly passed Federal Magistrates Act 1999. Then as now, the dominant purpose of the court was to provide a quicker and cheaper pathway for Australians to resolve their legal matters. From the outset, the court's jurisdiction covered important areas, including family law, human rights, administrative law, and trade practices. The court started with only 10 magistrates. Modest beginnings, yes, but the court's efficient exercise of federal jurisdiction eased the respective workloads of the Federal Court of Australia and the then Family Court of Australia. And by doing so, it helped improve justice for Australians. Indeed, the most novel and consequential feature of the court was its emphasis on user-friendly, streamlined procedures. Going to court can be daunting. By operating as informally as possible, while still ensuring the proper discharge of its judicial functions, the court focused on improving the way families and self-represented litigants interacted with the justice system. This focus was driven by prioritising alternative means of dispute resolution. By the time the Federal Magistrates Court became the Federal Circuit Court of Australia in 2013, the court had established itself as an indispensable interface between the Australian people and the federal judicial system. The number of judges that held appointments to the court had increased to 64, and central to the court's growing jurisdiction were family law, bankruptcy, and migration matters. In 2021, the establishment of the Federal Circuit and Family Court of Australia marked a new chapter for what we now know as the FCFCOA Division 2. It now has 91 judges, whose exceptional skill and training has enabled the court to adapt to changes in law over time. The court has developed an impressive reputation as the workhorse of the federal judiciary. This would not be possible without the dedicated staff who have served the court so reliably over the years, and to ensure the court can deliver its services across Australia. Whether listing a matter in Melbourne or supporting a circuit to Mount Gambier, the court's passionate staff are often the face of the justice system. The growth in demand for the work of the FCFCOA Division 2 is both a reflection of the pivotal role the court plays in supporting Australians when they need it most, and an endorsement of its success. It is this very growth in demand that has acted as a driving force for forward thinking and evolution over the last 25 years. While the court has adopted many innovative approaches since its inception, I would like to highlight some from recent years. There would be no more appropriate place to start than by acknowledging the court's most recent campaign to combat domestic and family violence against women, which brought together sport, prominent Australians, and a strong message to 60,000 footy fans at the MCG in Melbourne, and then another 60,000 fans at the State of Origin in Perth. More than simply an impactful campaign, this was a demonstration of the court's ability to reach Australians outside of our legal system, and by doing so to raise awareness and drive behavioural change. I acknowledge Chief Justice Alsterdgren's leading role in driving this case for change. The court's focus on domestic and family violence is also evident from recent developments in its own practice and procedure. In 2022, the world-leading Lighthouse program was introduced. Lighthouse ensures early identification of safety risks and the use of the most appropriate case management pathway, including referrals to support and health services, particularly for people at high risk. Over the years, the program has proven to be instrumental in supporting the court to more effectively protect and prioritise the safety of children and vulnerable individuals in family law proceedings by identifying the entrenched and prevailing risks of family violence. Another innovation has been the priority property pools cases model. The court, in close partnership with government, has established the model to fast-track small value property matters. Since its pilot in March 2020, this approach has been rolled out nationwide, providing a faster, more affordable and less stressful path to settlement for couples with small property pools. By streamlining the process, the court is delivering justice that is efficient and compassionate, helping families to resolve disputes quickly, to reduce costs and move forward with confidence. This model is a powerful example of how thoughtful reform can make a difference to the financial recovery and well-being of separated families. I also acknowledge the significant role of the court in implementing legislative reform. In the last 2 years, the government has progressed important amendments to the Family Law Act. This has involved the passage of 3 pieces of legislation to simplify and enhance the parenting and property frameworks of the Act and to improve the sharing of safety-related information. These reforms sought to better address family violence, to reduce the distress and hardship caused by protracted and adversarial litigation, and to make the legislative framework clearer, simpler, and better equipped to support vulnerable individuals, particularly children, in resolving parenting and property matters. The court now has a critical role to play in operationalising these reforms, as judicial officers apply the legislation to specific cases. I very much look forward to seeing the body of jurisprudence that develops and to monitor the ongoing impact of these reforms. Aside from the court's important work in the family law jurisdiction, the court has a leading role to play in the administration of broad areas of federal jurisdiction, including fair work and industrial law, migration, bankruptcy, human rights, and administrative law. Many of these jurisdictions have a deeply personal element, and the rights and obligations being considered by the court in these areas are fundamental to the Australian community. I acknowledge the work the court is doing across the general federal law and migration jurisdictions, which is reflected in the investment that has been made, in particular in the migration jurisdiction. I congratulate the court for its contributions to the administration of justice and to the Australian community over the past quarter of a century. I recognise the immense benefits that the commitment to service demonstrated by this court has had for the Australian community, including through its circuit program to regional and rural Australia. As Attorney-General, I am looking forward to working with the Chief Justice and the court to explore further innovations to strengthen access to justice and to ensure the court continues to make a real impact for those in our community who rely on its services at their time of need. May it please the court.
Thank you very much, Attorney General. Ms Rasheen Annesley, KC.
May it please the court. I appear on behalf of the Australian Bar Association to recognise the 25th anniversary of the Federal Circuit and Family Court of Australia, Division 2, and to wish the court a very happy 25th birthday. 25 years, it is a wonderful time in anyone's life. Indeed, I recall being 25. It was such a good age that there was a period of more than 10 years where I remained 25. However, I digress. Today is, after all, a day to recognise the achievements of this court. 25 years is a milestone in a court's life, and not one that modern practitioners have had occasion to celebrate in recent history. It is an appropriate time for reflection on what has been achieved and what is still to be achieved. There is a sense of stability, a recognition of the responsibility of the role of the court in the community and in the administration of justice, and a sense of optimism for the future direction and growth of the court. Division 2 of the Federal Circuit and Family Court of Australia epitomises the very model of a modern, innovative, efficient, hard-working court. The court is blessed with just over 90 judges, nearly all of whom I'm appearing before today, all of whom are vastly experienced and specialised practitioners, all of whom are dedicated servants of the court and the community. As we have heard, the court's work is extensive in its breadth, across family law, administrative law, bankruptcy, industrial relations, migration, consumer law, intellectual property. It is work which is also relentless. The bulk of the court's work is in family law, followed closely by migration law. Whilst it can be accepted that all litigation is stressful, it is also well recognised that parties appearing before this court in those two areas are without doubt experiencing extreme stress, uncertainty and emotional turmoil. Every member of Division 2 of the Federal Court and Family Court of Australia, from the Chief Justice down to the registry staff, are to be recognised and congratulated on the extraordinary efforts that have been made and are continued to be made on a daily basis to streamline and reduce the length of court proceedings, so that disputes are resolved as expeditiously, fairly and safely for all those concerned, particularly the most vulnerable. 25 years is recognised as a generation. The Federal Circuit and Family Law Court of Australia Division 2 is a modern court in and of its generation. On behalf of the Australian Bar Association, may I extend my warmest congratulations to the court on all that it has achieved and that is celebrated today on this milestone occasion. And may I extend to the court the very best wishes of all Australian barristers, particularly those who regularly appear before this court, for an exciting, harmonious and continued successful future. May it please the court.
Thanks very much, Ms. Innesley. Ms. Whittaker.
May it please the court. I too acknowledge the Gadigal of the Eora Nation. I give my respects to their elders past and present, and I extend that respect to all First Nations persons present today, especially to my learned friend Mr. Smith and to his family. Chief Justice, judges, it is a privilege to speak today on behalf of the New South Wales Bar Association to help mark this important occasion. Barristers, of course, owe an overriding duty to the court to act with independence in the interests of the administration of justice. We also feel the daily weight of being the agents of those who are the consumers of judicial service. Barristers are acutely aware that from the perspective of those who seek the aid of this court to achieve what they cannot effect without it, the court only exists through its human embodiments, most acutely through its judges and registrars. The role of court staff and experts in this court in particular must also be acknowledged. Part of what we reflect upon and recognise today is the important and difficult work of the judicial officers and those who work with them in the resolution of the types of disputes brought before this exceptional court. I lightly repeat the observation of the Chief Justice of the High Court, His Honour Justice Gageler, albeit several years before His Honour's appointment, that it was said over half a century ago in England that the function of a trial judge was to be quick, courteous, and wrong. It was immediately added that that did not mean that the function of the Court of Appeal was to be slow, rude, and right. If that were so, the Court of Appeal would then be usurping the function of the House of Lords. Justice Gageler went on to summarise the essential attributes of a judge as being, first, technical competence, secondly, practical judgment, thirdly, courtesy, and fourthly, industry. The point being that at a minimum, those are the four attributes that society should be able to expect in any judge, in any court. But the unique work of this court demands so much more from its judicial officers and support staff. It can be immediately appreciated that this court's core work of family law and migration hearings involve elements of human behaviour, conflict, vulnerability, damage, and emotional distress to a degree and of an intensity not seen in a number of important lists in Australia. Other general federal matters such as bankruptcy, fair work, and human rights also often involve these complexities. This court deals daily with people who are often at the most vulnerable and stressful points of their lives. Perhaps the only fair comparison is with the judges of criminal divisions. 3 things in particular struck me when I reviewed this court's, along with the Division 1 Court's, annual report for 2024 in preparation for this ceremonial sitting. The first is that this court's stated objectives include the just, safe, efficient and timely resolution of matters. The word safe does not appear in the otherwise similar statutory mandates in, for example, Section 56 of the Civil Procedure Act, New South Wales, or in Section 37M of the Federal Court of Australia Act. Its inclusion illuminates the nature of the disputes before the judges of this court. The second is that one of the court's guiding principles or philosophies is to place an emphasis on its response to family violence and risk to children. The public statements of your Chief Justice that the prevalence of family violence in Australia is a national disgrace also speaks volumes about the fact patterns coming before the judges of this court. My review of the noteworthy cases included in the annual report only confirmed the content. The third is that the volume of cases before the court and the speed with which they are determined, born no doubt from the significant procedural reforms directed towards a quick resolution, is substantial and seems destined to increase. These observations are significant in part because there is a growing body of research into the mental health effects, and in particular the effects of vicarious trauma, on judicial officers. These effects arise from the relatively isolated and highly scrutinised process of determining heavy caseloads involving distressing subject matters. That research includes subject matters of the type regularly before judges of this court. The term vicarious trauma, of course, describes the process and mechanism by which the inner experience of a person is profoundly changed through an empathetic bonding with another person's traumatic experience. The New South Wales Bar Association is committed to the mental health of its members, and in the course of fulfilling that objective, we are well aware of the potential for harm to the mental health of all participants in the administration of justice. I hesitate to repeat it, but some research suggests that judges dealing with, in particular, family law and criminal proceedings may have higher levels of secondary trauma than barristers appearing in those jurisdictions. Research also indicates that repeated or extreme exposure to events concerning domestic violence imposes a particular risk upon judicial officers. The personal experience of judges who have spoken about these matters publicly indicates that the determined focus and concentration of a conscientious judicial officer, sometimes referred to as the intimacy of the judicial officer with the proceedings, increases the burden. As one judicial author expressed it, we cannot just listen dispassionately to the evidence. We have to digest and literally judge the people before us. The people who chose to accept an appointment to this court are all persons who have chosen to do something that is noble. The pressures they face are all born of the importance of the work they do. It is coalface work that is critical to the well-being of our society and to the rule of law. The litigants and the public at large are rewarded by your diligence, application and expertise. Barristers' business models depend upon it. The rewards enjoyed by society are, we hope, mirrored by the rewards and personal enrichment the members and staff of the court receive from performing your exacting duties. As part of marking today's significant milestone, we acknowledge the work of the judges and registrars and staff of this court, and we recognise the toll that work can exact. On behalf of the New South Wales Bar Association, I express gratitude to those judicial officers and to those who support them for their extraordinary service. May it please the Court.
Thank you very much, Mrs. Whittaker. Ms. Warner.
May it please the Court. Following from those who have come before me, I echo the acknowledgement of the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation. And could I just say, Mr. Smith, that your address was wonderful and deeply moving. I also acknowledge, Your Honour, Chief Justice Alstigran, AO, and the Attorney General, the Honourable Michelle Rowland, MP, and this is actually the first formal event that I've had the pleasure of attending with the Attorney General since her appointment last month. So I'd like to take this opportunity to congratulate you in person. I would also like to acknowledge Australian Bar Association President Roseanne Annesley, KC, New South Wales Bar Association Junior Vice President Vanessa Whittaker, SC, President of the Law Society of New South Wales Jennifer Ball, and all the other luminaries in court today, and dignitaries and colleagues. First of all, let me commend those who led the establishment of the Federal Circuit Court of Australia Division 2 back in 1999, or the Federal Magistrates Court of Australia as it was known, for having the foresight to ensure it commenced sitting in a nice round year, the year 2000. So we can easily remember and note each passing year. And today in 2025, we come together to mark the 25th anniversary of this venerable institution. Until 2013, as we've heard, the Federal Circuit Court of Australia was known as the Federal Magistrates Court. The Federal Magistrates Court was created to deal with the increasing workload of the Federal Court of Australia and the Family Court of Australia. And when the creation of the Magistrates Court was announced by then Attorney General, the Honourable Darryl Williams AM KC, also a former Law Council President, I just had to get that in, its stated objective was to streamline procedures, reduce litigants' costs and reduce the time taken to resolve disputes. It was expected that the new court would free up Superior Court judges and that the service would promote the use of alternative dispute resolution, which 25 years ago was still pretty trendy and a bit modern. In his State of the Judicature speech in 2001, the Honourable Murray Gleeson, then Chief Justice of the High Court of Australia, called the establishment of the Federal Magistrates Court one of the most significant recent developments in our justice system. He noted that in just the year or so since it commenced, the court's workload has expanded rapidly. In places where it sits regularly, capital cities and major regional centres, it receives between a quarter and a third of all family law applications and most of the work of federal courts in bankruptcy and unlawful discrimination. It may be expected that the jurisdiction of the court will continue to expand. Well, it certainly has. Today, as has been essentially the case since its inception, the Federal Circuit and Family Court of Australia Division 2, or Divi 2, as people colloquially refer to it, is the largest federal court in Australia and has broad federal jurisdiction in areas including family law, migration, fair work, bankruptcy, intellectual property, consumer law, human rights, and admin law. And as so wisely predicted by Chief Justice Gleeson, the caseload of this court has continued to evolve. A significant change is the fact that in recent years, the court's migration workload has increased significantly and has for some time represented the second largest area of the court's jurisdiction after family law. The work of this court is nothing less than life-changing. This court and the state magistrates' courts are the engine rooms of justice in this country. It is this court that is the most likely to be called upon by everyday Australians for assistance during the most stressful and difficult and worst events of their lives. Just to give some small idea of the impact the court has, if we just look at the applications filed in 2023, 2024, I did some research too, from the annual FCFCOA annual report, the scope and outcomes are vast. There were 95,557 family law applications, 4,576 migration applications, and 3,079 applications were filed in the court's general federal law jurisdiction. While smaller in number, but no less important, there were 25 admin review matters that proceeded before the court, 1,382 bankruptcy applications, 406 consumer law filings, 217 small claims, 1,133 fair work applications, 109 human rights applications, and 20 intellectual property applications filed, and bringing up the rear, 4 in Admiralty. I had no idea you did Admiralty. In any event, that sounds like more than enough work, but I understand that the trends are indicating applications in all of these areas, maybe even in Admiralty, are going up. Now, the court, and under this umbrella, I include every person who has worked here or works here, has demonstrated in a variety of ways its understanding of the importance of its mandate and dedication to achieving its stated outcome of just, safe, efficient and timely resolution of matters. Initiatives have been trialled and implemented to improve access, safety and inclusiveness, consultation with and strengthening relationships with stakeholders, such as the Law Council, remains a priority, and the court has embraced innovation and technology to achieve its goals and risen to meet challenges such as those presented by COVID. Despite substantial increase in demand on the court's resources, its focus on timeliness is showing very positive results. But before I finish, I would like to share my admiration for all those who choose to serve our community through their service to this court. And this, of course, includes each of your honours here with us today. As President of the Law Council, I'm really privileged to be invited to ceremonies held to welcome each new judge and justice and to go to swearings in and swearings out. I'm very pleased to say that the swearings in have been very regularly held in recent years, which means your ranks are growing, as they should. And as they've been based on the growing application rates I mentioned earlier. But earlier this month, I was present to welcome Her Honour Judge Marquardt. And something happened at this ceremony that was a first, but I hope becomes the norm. And that was, as Judge Marquardt's speech finished, those attending the swearing in broke into a spontaneous round of applause. I can't tell you how often I have felt like clapping at some of these events, and you can't, you have to sit there po-faced. Well, that didn't happen on that occasion. These ceremonies are actually joyful occasions, and I love that they provide an opportunity for us to meet and get to know a little about each of the judges who serve so selflessly. We learn about their favourite hobbies, their families, and even their beloved fur babies, and I can see some people whose fur babies I know a bit about. We learn about them as people, and not just as lawyers and the cases that they have done. The individuals who preside over this court are wonderful and talented people, and as new members join your ranks, it is an opportunity to celebrate them and to celebrate the court and all of its outstanding judges and staff. And therefore, I believe that thunderous applause should always be the order of the day at swearings in and swearings out. And I leave that to you, Chief Justice, to forge forward with. This court most definitely has my appreciation and thanks. For 25 years, this court has been an integral and central pillar of Australia's globally envied justice system. On behalf of Australia's legal profession, I congratulate you on the undeniable contribution made to the administration of justice in this country over the past 2.5 decades, and which I know will undoubtedly continue well beyond our celebration of today's milestone. As the court pleases.
Thank you, Ms. Warner. Ms. Ball.
May it please the court. I too echo and acknowledge the traditional custodians of the land on which this court is sitting, the Gadigal people of the Eora Nation, and pay my respects to their elders past and present. I also acknowledge the Honourable Chief Justice Alstergren presiding, all your honours brother and sister judges present, my learned friends at the bar table, colleagues and every person who has come before this court in all its forms over 25 years. Thank you, Chief Justice, for inviting the Law Society of New South Wales to address the court today. In the National Archives in Kew in the United Kingdom lies a list. It begot other lists like it, but it is the first of its kind. It is the roll of admission of solicitors in the Court of Common Pleas. It begins in 1729. As far as I am aware, it is the oldest extant mandatory roll of admission of solicitors in the English common law record. This is really the first time we see a modern recording of this profession's lineage, which, along with the President of the Law Council of Australia, Juliana Warner, I represent a continuation of today. That this record begins in the Court of Common Pleas is appropriate. It arose to hear cases between subject and subject, as opposed to those involving the King. Cases like many of those before this court, all these years later. Now we are not in England anymore. I hope this much is clear. And while these dates may conjure images of powdered faces, voluminous dress, and huge white wigs, some of which we still see in our courts today, that is not the central point. Today, nearly 300 years later, on the other side of the world, we have taken all of that, and the Federal Circuit and Family Court of Australia Division 2 is the largest federal court in this country. It is the single point of entry for all federal family law disputes, that area of law which last year constituted, as we have heard, over 95,000 filings in this court. These sit alongside thousands of other matters concerning migration, fair work, bankruptcy, intellectual property, consumer law, human rights and administrative law. Simultaneously, there are more members of the Law Society of New South Wales than there are solicitors in any other state, and the whole of the United Kingdom back in 1729. We contribute much of the legal representation in this court. But one may wonder why I mention these things today, when we are here to celebrate the wonderful 25th anniversary of this court. I will make what seems like another unrelated point, my last, before I tie them together. No one wants to see their relationships break down. No one in this court today here wants to see their relationship with their partner or family, with this country, their employer or their business, to crack or dissolve or be rendered apart. Sadly, it is as common as the night. But long before King George II made rolls of admission of solicitors mandatory, people have been wanting to do the same thing, to keep their relationships alive, just like us today, right now. It is the driver of pleadings in this court, the time and concern, focus and care given to those appearing comes from this in so many ways. It takes a huge amount of cooperation between court staff, registrars, judges, lawyers, and indeed the individuals appearing for common law doctrines like, say, procedural fairness and precedents such as Gillick competence to be made out. And in those moments, people's relationships are fixed, remade, or broken. In 1958, the Commissioner of Police versus Tanos, Chief Justice Dixon and Justice Webb of the High Court of Australia described, and I quote, "A deep-rooted principle of the law that before anyone can be punished or prejudiced in his person or property by any judicial or quasi-judicial proceeding, he must be afforded an adequate opportunity of being heard. Heard to maintain their relationship with their child, with Australia, with their house, physical liberty, or indeed, in a way, their past. The law this court presides over is human to its core. Things were not always like this, and we do not need to go back to 1729 to see that this Federal Circuit Court in its various guises has changed the way federal courts operate in its 25 years of existence and changed it in a deeply positive manner. Lighthouse is a world's first initiative of the court, with the court's commitment to protect vulnerable parties and children in family law proceedings, to screen family law litigants for major risks in applications seeking parenting orders. Dispute resolution is widely used to reduce costs, delay and emotional stress. The case management pathway for family law has been greatly streamlined. This court is a single point for entry for all family law matters that may come before Division 1 or 2. There have been vast technological improvements, with initiating applications filed electronically in 90% of cases, when 6 years ago that was around 40%. And court hearings are easily conducted by video conferencing now, improving access to justice across Australia. There is much, much more, far more that can be summed up today. But what these and more deeply positive changes mean in total is this: wait times for final orders applications have been greatly reduced. The number of cases on judges' dockets have been greatly reduced. And the length of cases has been greatly reduced. Improvements like these make justice faster, more affordable, and better for the people who need this court. We can also go back to, say, 1729 and much earlier to see that tragically some things in human nature that this court has jurisdiction to hear remain constant. Take, for example, notices of child abuse, family violence or risk. Last year, these notices indicated that 70% of parenting cases involve allegations of 4 or more risk factors, including family violence, child abuse, mental health concerns, drug and alcohol abuse, threats of harm, and risk of abduction. Disturbingly, and as is borne out by much social science, whether anthropology, history or archaeology, these issues have been in many families and societies across cultures and places for hundreds, indeed tragically thousands of years. What we are here to celebrate then today is a bulwark against the worst of what can happen when relationships break down. The past 25 years of this court shows a refined empathy for the people who need to appear here. This is a part of a larger trajectory, one which encompasses the continual improvement of relief and reflection of wider society within the jurisdiction of the law. Looking at an even bigger picture, we can hear a distant whisper of things improving in the distance between justice and outcomes. I'm not as naive as this may sound. The world is not without its problems. This does not apply to all evenly, and I do not wish to diminish or silence for one split second, say, a child who was abused by his father in his home as his parents separate. None of what I have said matters to him. But were it not for legal institutions like this over the past 25 years, which represent a trend of increasing human concern, especially since the last quarter of the 20th century, we would, I believe, unarguably be worse off. Your Honour, on behalf of the more than 43,000 solicitors of New South Wales, I congratulate the bench of the Federal Circuit and Family Court of Australia, Division 2, on this, the 25th anniversary of the court, as the court pleases.
Thank you very much, Ms. Ball. I thank each of the speakers for their kind remarks and the respect they have shown for our court. Today we reflect how far we've come. It is fitting this ceremony is held today, as the 23rd of June marks exactly 25 years since the court received its very first applications for filing. This is a court whose relatively short history has been marked by hard work, innovation, resilience and a steadfast commitment to access to justice. The court was established by the Commonwealth Parliament at the end of 1999, marking the change in direction in the administration of justice at federal level in Australia. It was the first lower level trial court created in the federal judicial system since the passing of the Judiciary Act in 1903. The Honourable Diana Bryant, who's here today, was selected to lead what would initially be referred to as the Federal Magistrates Service, a name that the court quickly outgrew. Instead, the court was known as the Federal Magistrates Court. First order of business for the newly appointed head of jurisdiction and for this new institution was to find suitably qualified people willing to step into the unknown, to build a court from the ground up. Having progressed through panel interviews, an exam, and finally a further interview with the then Attorney General, federal magistrates Donald, Ryan, Bowman, Scarlett, Croker, Mead, McGuinness, Hartnett and Brewster joined Chief Federal Magistrate Bryant as the original judicial officers of this court. It is apt to note that 3 of the original judges are still serving the people of Australia as Justices of the Federal Circuit and Family Court of Australia Division 1, or the Family Court. Justice Bowman was a long-standing National Case Management Judge of our court and is currently the Case Management Judge for the Brisbane Registry for both courts. Justice Hartnett is presently the National Case Management Judge of the Family Court of Australia, or the Federal Circuit and Family Court of Australia, and Justice Mead, who retires next week, has been one of our longest-serving and most senior judges in Adelaide. It is wonderful they're all here today. The new magistrates commenced their joint orientation in Wood End, a small country town in Victoria. For many of them, it was the first time they'd actually met. They would each indicate their vision, their enthusiasm to be part of a new court and do things differently. When reflecting upon the 10-year anniversary of the court, Federal Magistrate Donald spoke of a pact that was formed during that orientation in Wood End. The pact was to support each other. It was agreed that no matter what, if one of the federal magistrates needed to discuss an issue or put a call out to their colleagues, each would drop whatever they were doing and whatever they could do to make sure they supported each other. Those who've sat on this court ever since have done the same thing. It's interesting to see how successful the court has been. Initially, the court faced external criticism, doubt, and indeed at times obstruction. However, with the great assistance of the hard-working staff of the court's first CEO, Peter May, and who's been described as a force of nature, the court's inaugural registrar, Adele Byrne, and the court services expertise of Steve Agnew, the court navigated its first years with ingenuity and determination. The court carried a clear and ambitious mandate to deliver justice that was quicker, simpler, and more accessible. Its judges travelled widely, sitting in capital cities and regional towns, often in borrowed courtrooms. It was in every sense a circuit court, bringing justice to the people rather than requiring the people to come to justice. The Honourable Diana Bryant led the court admirably for the first 4 years until she was elevated appropriately to be the third Chief Justice of the Family Court of Australia. That saw the Honourable John Pascoe, AOCVO, become the court's second Federal Magistrate, or Chief Federal Magistrate, on the 23rd of August 2004. He was tasked with leading the court that was rapidly growing in size and jurisdiction. He did so with poise, with determination, in what was an incredibly difficult time for the court. In those years, the court's success was quite staggering. The jurisdiction grew from a limited jurisdiction in each of family law and general federal law to broad and largely concurrent jurisdiction with superior courts in most areas. In this way, the court established a standalone identity, a reputation not as a court to receive the overflow of filings from other courts, but a court ready and willing to meet the needs of the Australian public and fulfil its important place in the judicial hierarchy. Indeed, in 2005, the court was hearing the majority of migration matters, having received the same jurisdiction as the High Court, pursuant to Section 75 of the Constitution, and nearly all bankruptcy work. Its jurisdiction grew from conferred jurisdiction in 16 acts to more than 70 acts within 15 years. It also included broad areas of consumer law, human rights, fair work or industrial law, intellectual property, admiralty and administrative law. It is often said that the multi-jurisdictional nature of this court has in part led to its great success. The cross-pollinisation of best practice procedures, case management, legal principle and education across different jurisdictions has built a strong, forward-thinking, responsive court. As the court approaches 10th anniversary, it had grown from 10 to 60 judicial officers, as well as substantial growth in terms of jurisdictions and filings over that time. However, there were also moves at that stage suggested for structural change. Thankfully, after proper consideration and consultation, the then Attorney General, our very own Deputy Chief Judge, McClellan, chose not to pursue such absurd ideas. In 2013, in recognition of the court's growing stature and the complexity of the work being undertaken, the court was renamed and celebrated in this very courtroom, the Federal Circuit Court of Australia, and its federal magistrates were recognised as judges. As the then Chief Justice of the High Court of Australia, the Honourable Robert French, AC, said, the renaming was more than merely cosmetic, but rather marked its coming of maturity as a significant national institution. By this time, the court had grown to be the largest federal court in the country, handling the majority of family law filings and a significant portion of general federal law matters. I want to acknowledge on this occasion the extraordinary commitment of former Attorney General, the Honourable Nicola Roxon, and the support of Parliament of the day, who recognised the need for the court and its judicial officers to be properly titled as judges, and that it would become an intermediate court. Former Attorney General Roxon noted that the change of title better reflected their important role in the federal judicial system, and that the title of judge would better recognise the character and the importance of the work undertaken by the court and enable its approach in the future with confidence. However, further changes were needed. By 2017, the court had two existing systems, two existing courts with almost identical jurisdiction, but with different rules, different case management processes and different procedures, conflicting court forms, websites, and sometimes even different names for the same basic parts of the court's administration. While the passage of the Federal Circuit and Family Court of Australia Act in 2021 would bring much debate and perhaps at times hysterical reaction, and even at times apprehension, the court used the opportunity to be innovative and responsive to the needs of the Australian people. Those needs have never strayed far from the first objects of the court to provide clearer and cost-effective access to justice. Over the past 5 years, a significant reform agenda has been implemented across both this court and the Federal Circuit and Family Court of Australia, Division 1. This is not about structure of the courts or the names they are given. It's about the substance, their ethos, and the outcomes they deliver. Both the Family Court of Australia and the Federal Circuit and Family Court, both the Family Court and the Federal Circuit Court of Australia continue their proud histories as independent Chapter 3 courts. In family law, the court has maintained a focus on the needs of litigants and children, their safety, their well-being, and their ability to move forward with their lives, not noise and not agendas. For the court, it's been about constructive and informed conversations on how we may together give Australian families the kind of family law system they deserve. In general federal law and migration, the court has successfully demonstrated a significant need for additional resources and, importantly, how those resources could make a difference, particularly in our migration jurisdiction. The government, to its great credit, recognised this with the appointment of an additional 14 general federal law judges to our court, as well as registrars and support staff. The court has great specialist expertise in general federal law and migration, and the court is seeing growing demand for its services in these areas from the public and from the profession, particularly in rural and regional locations. At the same time, we've also been able to recruit some of the brightest members of the profession. In 2001, the then Chief Justice of the High Court, the Honourable Murray Gleeson ACKC, predicted that the court would become one of Australia's largest courts, a prediction that has now quickly been fulfilled. Indeed, it is true that in more than one respect, the court now has 91 judges and hears a majority of matters in the federal law system. It also reaches out to the community across a huge geographical spread, with registries from Launceston to Rockhampton to Perth. The court also has a proud history of striving to meet the needs of all Australian people, including First Nations families. The court was the first court, as we've heard, in Australia to adopt a formal reconciliation action plan in 2014. The same year, the court began its first specialist Indigenous list for Aboriginal and Torres Strait Islander families in Sydney. Today, the court's specialist Indigenous lists operate in many registries across the country, supported by a team of Indigenous family liaison officers under First Nations leadership. The court is immensely proud to have had its first Indigenous judge appointed to the court, Judge Matthew Myers AM, who I know is watching online. I want to acknowledge his outstanding contribution to this court. We are proud to be a truly modern court, reflective of the Australian people. It is noteworthy that this court, it's noteworthy that on this court, over 50% of the judges are women. It is my hope and expectation that over time, the judiciary of this court will further reflect the remarkable multiculturalism and diversity of modern Australia. Whilst I cannot thank each of the judges by name, my words of thanks indeed are for each of them. Judicial office is not for everyone. It's an extraordinary responsibility. My colleagues on the bench today and those prior have all answered the call for a life of public duty, public criticism and public office, as have their families. I thank you all sincerely for your commitment to the institution that is so fundamental to our society. There are numerous judges who have held case management responsibilities or pastoral care responsibilities for the court in their registries, regions and nationally. I want to acknowledge the Deputy Chief Justice for their outstanding leadership and the work the Honourable Justice Bowman AM has led the court in his judicial case management for more than 15 years and is a great leader of our court. I also want to thank the staff of this court for over 25 years for their service. Like the 10 federal magistrates who saw their appointment to this court not as a recognition of individual achievement, but rather a call to service for the people of Australia, our court has been blessed with staff that have been driven and determined. They have given their all to serve those who looked to this court for an outcome, often during the most vulnerable times in their lives. It is the culture of this court which is its greatest resource. Collegiality, respect and kindness each of the judges shows for each other is commendable. The compassion and dedication of each judge, registrar and staff member of this court has for its litigants underpins its capacity to manage its massive national workload. It is not only the largest court, but the most far-reaching of any Chapter 3 court in Australia. Alluding to another decision of the High Court, if I may, Justice Simon Stewart of the High Court of Australia said in a recent case, anyone familiar with the work of what was formerly known as the Federal Circuit Court, that's now Division 2, should acknowledge that the judges of that court decide cases with great complexity. Indeed, usually, the complexity is equal to that faced by judges of the Federal Court of Australia or what was the former Family Court of Australia, traversing the same subject matters, such as family law, industrial, migration and bankruptcy. Those cases are resolved at a standard of judicial skill which is expected to be equivalent to that displayed by judges of superior courts. Anyone reviewing the judgments of the Federal Circuit Court would see that this standard is ordinarily met. I acknowledge the court's past executive officers, Peter May, John Matheson, Richard Foster, Stuart Fennick and Louise Anderson. I particularly acknowledge the dedication of our current CEO and Principal Registrar David Pringle PSM and thank him sincerely for the support he continues to provide me and the court to strengthen our very court. I also want to acknowledge our Deputy Chief Executive Officer and Deputy Principal Registrar, who probably has the largest title in the court, Virginia Wilson. At times, she is an unsung hero of this court, whose quiet resilience, skill and drive does not go unnoticed. I also acknowledge my legal and policy team of Jordan DiCarlo and Fraser Jones, who provide wisdom beyond their years, and Alex Butler for the extraordinary feat of putting this event on. I acknowledge every member of our staff, registrars, court child experts, associates, legal case managers, administrative, corporate and registry staff. They do such an amazing job and are incredible people who work tirelessly every day. You form the foundation of our great court. We will not be where we are without you. Thank you. And to the legal profession, you've shared our journey and our challenges. We are most grateful for your support. While we continue to be a young court, so much has been achieved over the last 25 years. May this court remain and always aspire to be an efficient, innovative and hard-working court, delivering justice to Australians no matter where they live. Thank you all for honouring us with your attendance today. Please join us for refreshments outside and view the amazing collage of photos that have been put together by Denise Healy. Thanks once again, Attorney General. Adjourn the court.
Silence, all stand and remain standing. The Federal Circuit and Family Court of Australia, Division 2, is now adjourned.